The Supreme Court of Canada recently ruled that Indigenous people who suffered heinous abuse in Canada's so-called Indian residential schools can opt to destroy the testimony they gave during the claims process. It was a unanimous decision that means thousands of eyewitness accounts could disappear over the next 15 years rather than take their place as part of Canada's official archives. Joining us now to reflect on the significance of this decision for the survivors and the historical record, in Calgary, Alberta, Kathleen Mahoney. She's a professor of law at the University of Calgary who represented the Assembly of First Nations at the aforementioned Supreme Court case. In Winnipeg, Manitoba, Ry Moran, that's him on the right, director of the National Centre for Truth and Reconciliation. And Eugene Archon, former residential school student and a member of the National Centre for Truth and Reconciliation's Governing Circle. And with us here in studio, Mike Kakagi. He's a former residential school student and a past president of the National Residential School Survivors Society. And it's an honor to have all of you on our program tonight to tackle what is, a really, really controversial topic, and we'll see how well we do trying to get everybody's views on the record here. And let's start in Calgary, Alberta. Kathleen Mahoney, I want to know what your reaction was when you first heard the unanimous decision by the Supreme Court of Canada that would permit the destroying of the records of those who want them destroyed.
Well, first of all, Steve, I would say that the characterization of this case is better described as being about consent, ownership, and self-determination, as opposed to destruction, because destruction is just an outcome of those fundamental principles that are embedded in the agreement. So I was participating as a representative of the AFN in the negotiations, and that was what the bargain was that it was a very clear agreement with Canada that these documents, especially the IAP testimony and the decisions, would be utmost confidential documents because they contain the details of horrendous abuse that are humiliating, embarrassing, all of those things. And it was up to the survivor as to what they wanted to do with them. So their consent is front and center in this whole dispute as to whether or not Canada gets to decide or whether or not the survivors get to decide.
Sure, and we've got to figure out where
the agreement said the survivors and the court said the survivors. So I applaud that because it goes down the road of human rights, self-determination, and the dignity and human rights of the survivors themselves.
We do, you're quite right, have to figure out where the balance of responsibility sort of lies here and whose rights are supreme. And let me get Ry Moran to come in next and follow you up by asking you where you believe the balance lies.
Well, as I think Kathleen has said, this is a very complicated case, and everything that she has said about self-determination, Indigenous rights, human rights is absolutely at the center of this case. One of the challenges that we've kind of uncovered in this case, though, is we're now 10 years into the process, and many survivors were not provided that choice before. Many survivors have passed on. That has left the collective group of organizations and survivors now in a position of trying to figure out what the most respectful, most honorable thing to do is with these records. Certainly consent is paramount. Certainly consent is a very important element of this entire discussion. The transcripts are one of those records. But we do need to ask ourselves, what about the decisions that were rendered? What about those decisions that were rendered by adjudicators in the interpretation of law? Is that the same as a survivor transcript? Is that a different type of record that's important for this country to understand?
And let me follow up with the gentleman beside you. Eugene, what's your view on where the onus of responsibility lies, to the values of the survivors or to the historical record? What's your view?
Well, first of all, I'm very, I guess, conflicted with all of this. I'm very happy, as are most survivors, that consent was achieved. But the process in achieving consent was a process of re-victimization to Indian residential school survivors. And by that I'm talking about the arguments put forward in the Supreme Court that day were about protecting our privacy. And when you look at the summary of student-on-student abuse, indicating that it was only in the area of 30 to 40%. And then you have the clergy abuse and the staff abuse of students over 60%. It really makes me wonder whether our privacy was a priority, or is this a process of destroying Canadian history? Because too many have passed on to provide consent.
So I'm hearing from you, Eugene, that it sounds like you're saying you are more concerned about history being airbrushed out as opposed to the rights of those who are testifying. Do I have that right?
Absolutely, absolutely. It's any type of erasing of history, any type of censorship or sanitizing of history as it relates to Indian residential school survivors is plain wrong. And we're supposedly celebrating 150 years. And we can't allow this to happen in 2017. This true history has to be continue to be preserved for generations to come.
Mike Kakagi, you're hearing some of the complexity of this debate on this very program already. Where do you come down on it?
Well, listening to both Kathleen and Eugene, and I have a lot of respect for both of them on their opinions, but you're getting one that's based on legalese and another one coming from the grassroots. And I always have a tendency as a First Nation person to connect with the grassroots more closely than I do with the legalese. An elder once said that my history is on my lips. Okay, now having taken that and extending that and looking back at this whole process with the Indian residential school, and you can see the contradiction in that. And like our elders say, when I speak for people to hear me. And we're an oral society, so when you have history come back and re-engineering who we were over 130 years, and at the end of it all saying, well, one of the bases of your culture, the cornerstone of the culture of who you are, is your oral history, we're going to take exception to that now. What some people have said, and when I went through my hearing, my IAP hearing, I went in there with this specific purpose of having that preserved and being told to the next generations on what happened.
But that was your choice. For
That
those
was
who,
my choice,
For
right.
those who choose a different outcome.
Well, but then again, when you look back at the mass, okay, and you're looking back at 38,000 testimonies here, how much time and energy was taken to ask those individuals, like Eugene mentioned, to do, were requested to do with their records. You know, when you look back at the residential school settlement agreement, to come down and have individual consultation with the individuals all concerned that were under the umbrella, very, very little of that happened. Very little of that happened. And I challenge anyone to produce records that they can show that the masses were consulted.
Well, let me try, Kathleen Mahoney, let me get you to come back in.
One thing that's very important, Mike, to understand is that every single one of the 38,762 applicants that came before the IAP to tell their stories were promised that their stories would be held in utmost confidence, and everybody signed documents to that effect. Now, it's not to say that person can't disclose if they wish. 7,000 people have preserved history by coming forward to the TRC, and I was just reviewing the 4 volumes yesterday. It's an incredible detail, extremely well-written account of what went on in the Truth Commission and those 7,000 stories that are referred to in those documents. So history has been preserved. What we're talking about here, it seems to me, is a fundamental principle of human dignity. Like when a child is abused in the normal course of events in a court hearing, the public never has access to the details of how that abuse occurred because it is so damaging. It is understood to be so damaging to that individual to have that publicly displayed, that kind of detail. So the courts preserve and protect that child's testimony or any other testimony pertinent to the details of that abuse. So I asked myself, what is to be gained to have the prurient details of the abuse? We know the abuse occurred. There's been thousands of people talk publicly about their abuse. We know from the apology, we know from the whole residential school settlement, of which more than almost $4 billion have been paid out in compensation. We know that people have proven that they were abused. In I think of the 38,000, over 80% cases were successful. So we know that. We know what happened in residential schools.
Professor Mahoney, can I jump in? Can I jump in?
The protection of the individuals.
Let me jump in by asking you, though, to speak more directly, if you can, to both Eugene's and Mike's point that there is a concern, privacy, of course, but what about another concern that somehow history is being airbrushed away here because of the potential destruction of the record?
Yes, well, I think I addressed that point, Stephen, the fact that 7,000 people have come before the TRC
But that's 7,000 out of 38,000. That's 7,000 out of 38,000, which is a fraction.
That's right. But of those 38,000, we know how many people have been successful in their claims of claiming this abuse. So we know it happened. There's no doubt that it happened. And there will never be any doubt that it happened. The question here is, to what level of detail should the public be allowed to against the consent of the victims, find out all the horrible details of what happened to them. And so consent is, like I said, front and center here. Everybody is free to archive their documents if they wish, every single survivor. But the key here is their self-determination, their consent.
Okay,
and
Mike,
if they wish to do that, it will be preserved.
Let me get Mike Kakaji's feedback on that. You've heard her point?
Again, being very, very respectful to Professor Mahoney, in that instance that she mentioned about her child being abused. Our concern is the perpetrators. In the process of destroying those testimonies of those that were abused, the actions of the perpetrators and their roles that they played in all this abuse are also destroyed.
Eugene, is that a concern of yours as well?
Oh, it definitely is a concern. And also, along with that concern is Professor Mahoney just talked about the $4 billion that was dished out to IEP claimants. Well, let me tell you this. I've been coast to coast to coast with survivors, and I don't know of one residential school survivor who has become extremely rich off of this process. But I know of many lawyers and law firms and communications companies who have become extremely rich off the backs of our misery. So when we look at consent, yes, that was a good process. The process of going to Supreme Court was a process of re-victimization because it wasn't about our privacy. It was about the privacy of the 60% plus that were involved as perpetrators. And from the start of this agreement, we were told we would get the benefit of the doubt. And when we have the perpetrators administering this agreement right up till today through the IAP process, we have some problems that are not consistent with the work of the Truth and Reconciliation Commission. There is no reconciliation here at this point. And it continues to be perpetrated by those in positions of power.
Eugene, just for the record, I'm sure Professor Mahoney wasn't suggesting that somehow the victims are getting rich, off the backs of Canadian taxpayers out of this.
No.
There's no question
Canada was the perpetrator, and Canada was the one wanting to have these documents disclosed to the public. So I don't really understand that argument at all.
Recently, there was a press release given out by the IAP Secretariat in regards to different amounts of compensation or monies that were distributed through the process. Not once in that press release was there any indication of those that profited from this agreement. No matter how you look at it, it wasn't done. So the perception of the Canadian public out there is that, okay, you residential school survivors, move on, you've been compensated. Well, it hasn't been compensation to the effect of any type of healing. It's been a process of re-victimization.
With respect, Eugene, those are completely different issues from what was before the court with respect to whether or not individual claimants should have their records made public without their consent.
Well, I think one of the things that we can reflect on here as well is we just have to acknowledge that there is a tension in this case, and it is an unresolved tension, and that's that balance between collective and individual rights. So when we talk about the individual's right to privacy, absolutely that is central in this case. There's no question about that. There's no question that survivors were promised absolute confidentiality. But one of the things that was discussed at length in this case was whether or not that confidentiality could be maintained while still retaining the collective right to know. The sad reality about this history of abuse that has been inflicted on Indigenous peoples from coast to coast to coast is that generations will be feeling the effects of that abuse for years to come. And this is not going to be resolved in 10, 15, 20 years. Indigenous communities have been greatly impacted by this. So the question is, you know, could the documents have been redacted? Could they have been blacked out? Could they have been sealed for 50 years? Could they have been sealed for 100 years? And there's that very real tension between collective rights and individual rights. When we look at things through the narrow lens of individual rights to privacy, there is that collective right to know that is placed in peril with this. And that's a challenging element to this case. I mean, I think the other thing too that's fundamental is, what about the administration of the process? What about the $4 billion? Were survivors treated fairly by the process? And we know when we were with the Truth and Reconciliation Commission, we heard a lot of criticism about the IAP process itself because it was very invasive. We have to recognize that our actions here in this country may be examined, ought to be examined by other nations in the world attempting to address mass human rights violations. How did this process work? Was it fair? Was it effective for survivors, as I lose my earpiece here? Were survivors treated respectfully in the process? Was the compensation doled out in an appropriate way? We really don't have that ability to scrutinize the process en masse now. And that's where there is this distinction between, say, the decisions that were rendered by adjudicators operating on behalf of the Crown, administering decisions that would result in the disbursement of public funds.
On behalf of the Crown, the adjudicators were independent, right? That was a critical part of this whole process. Canada wasn't administering the IAP. That was an independent process.
So let's not call it the Crown, but you know, still responsible for rendering decisions that were collectively interested by the parties to the settlement agreement to be in the national interest for everybody.
Yes, they were independent. Right?
Yes, they were isolated from Canada, but still responsible for deciding on the veracity of the testimony provided by survivors.
Okay,
and the
let me
level
jump
of
in here,
compensation
if I can. Let me jump in. We got a lot of ground to cover, and I've got a residential school survivor sitting right beside me, so I want to talk to him. Okay, Mike, where'd you go to residential school?
I went to 3 of them. The first one was in Chapleau, Ontario, and then one up in Moose Factory, and then the final one was in Shingwag in Sault Ste. Marie.
So all 3 in the province of Ontario?
All 3 in the province of Ontario.
How old were you when you first went?
I was 4 and a half, and I got out when I was 16, just turning 17.
So you went 12 years.
12 and a half years.
How was it?
Not very nice. Not very nice. Subsequent to my exposure in residential school, the work that I've been doing for the last 15 or 20 years has been working directly with survivors. The organization that I worked for, the Children of Shigwak, and the ones that took up after, we worked directly in the IAP environment. We went right into those particular hearings. We heard, we have a staff of 14 or 16 people.
But did you go through that yourself?
I went through it ourselves, but as a support person, we sat in on every hearing that was occurred in the province of Ontario, and we heard all the horror stories. We were in the trenches under direct fire, for a better way of putting it. Mm-hmm. But what happens at the end of the day, okay, and this is where I have confusion with the facts and when people speak. At the end of you going through 6 or 7 hours of testimony, reliving probably some of the most horrible experiences you've had as a child, and at the end of the day, there's a statement made or a question asked to the survivors, well, what do you want done with your records? At that particular time and after what they've endured and what they've been exposed to, the last thing they're worried about, Steve, is what's going to happen to those records.
So you think they're not in a position to make a good decision at that point?
At that particular time, and even when they left, because a lot of them left with their families never knowing. Okay, and in these particular cases, I fully support them for their records being destroyed if they so choose, but also because a lot of the horrors, probably the most horrific stories, and you wouldn't get that at a TRC event. You get them in, right, like I say, right in the hearing rooms.
Where did you do your hearing?
In Sault Ste. Marie.
In what kind of a place?
It was a hotel.
In a hotel?
Yeah, and you see, and even then, when you go back and everyone signs an oath of confidentiality or statement of confidentiality, but then, let us say, at that given time, I had an 83-year-old woman for the first time in her life talking about her experience. So when you look back at, you weigh all those factors, and I probably was both subjective and objective because of the experience I've had enduring maybe 5 or 6, maybe 1,000 hearings.
Let me find from Eugene similar information. Which residential schools were you in, Eugene?
I was in LeBret for St. Michael's School in Duck Lake for 9 years, and in LeBret for 2 years. So a total of 11 years from 1958 to 1969.
And which province was that in?
In Saskatchewan.
In Saskatchewan. How would you characterize your experience there?
It was not very nice. I wouldn't wish it on any child that's alive today.
You were abused?
Yeah, that's... Let me clarify something.
Sure.
I went through the IAP process myself. It was a horrendous experience, right from discovery on through the system. And I'm okay with the settlement that I received. What I'm not okay with is many of our fellow residential school survivors who did not have a settlement that was, I guess, fair settlement.
Commensurate to their suffering, in other words.
Exactly. And there were many. That's the thing with this independent process of the IAP Secretariat. There was very little room for advocacy, and there was very little room for appeals. And the appeals that did go forward, and I have one sitting right in front of me, it was like the system was there to protect that system. And there was a huge number of people being rejected, dismissed. There was cherry picking going on amongst the law societies or the law firms who decided that you weren't abused enough for them to retain their 15%, and to be able to make a good buck off of our negative experiences.
Well, Eugene, you've raised this. Can you tell me whether you think too many lawyers got rich off this at the expense of the victims involved?
Oh, definitely. I have a document in front of me that was forwarded to Saskatchewan Law Society in regards to any type of positive advocacy to come from the Law Society in regards to what was going on in Saskatchewan. There has been no. It's just like do what you want until you get caught, and now. The person who forwarded that letter to the Saskatchewan Law Society has been, I guess, on the web.
Well, we heard one lawyer.
In a real negative way.
Yeah, we heard one lawyer had to pay $2 million back because of overbilling.
Well, there's over 50 lawyers that had to pay money back, and there's been no public identification of who these are. But when you travel in circles I travel in, and you see and experience the re-victimization that occurred to these people who went through discovery, spilled their guts, and then went through a process and were called liars and making up stories time and time again, and today are living in a subsistence level, addicted more to drugs and alcohol than before they went through the process. This is the misery that my people are living in, and there's many of those, and nobody wants to review any of those cases.
Okay, Eugene, stand by 1 second. Mike Kekagee wants in here. Go ahead, Mike.
Hi. When you talk about records, there's a school here in Ontario, up in the James Bay coast, okay, Fort Albany, St. Anne's. They've been struggling for years, okay. There was before the residential settlement agreement occurred, there was an investigation by the OPP. And there was records retained, and Canada had those records. And they've been fighting since that time to get access to those records. So when we hear about destructions of records or secrecy and all that,
you get concerned.
Okay? And the other thing, when you talk about the settlement agreement, if you look at the settlement agreement, you can sit down and read it. Every place along the system where there's $1 involved, you'll find lawyers. and you just follow the dollars to the agreement, you find dollars. And I question, like, you don't go to the Supreme Court with $500. Mm-hmm. Who paid for the money? Who put the front of the money and the resources to take this case all the way up to the Supreme Court of Canada to get this decision? Okay? And having had that decision, then once that decision has been rendered, is there any resources left to contact those survivors that may want or may not wish to have their records destroyed? Again, you see, if that happens, Steve, then who's compromised are the survivors.
Right.
Kathleen Mahoney, I hear you trying to get in.
I just wanted to make a few things clear about this debate, because the IAP records, which is the subject matter of this discussion, and whether or not they should be made public or whether or not the wishes of the claimant should be respected. Some claimants may wish to make them public, others may not. The disclosure of those records would not answer the questions that Eugene and Mike are raising. Those are separate questions about the process, and they certainly have very valid points to make. The process itself allows many levels of appeal. And like the question Mike was just talking about, documents, those are separate. That was a separate issue with respect to whether Canada should produce documents about St. Anne's School. That has gone through the courts, because you can go from the adjudicator, you can go to a first review, a second review, and then you can go to the courts. And that's what's happened. There's judges that have been assigned to hear these ultimate appeals, and in many cases, most cases, they've been decided in favor of the claimants. But it is a process, and for sure it's a processes such as this are difficult and complex, but there has been avenues of appeal. People haven't been shut down without a hearing in most cases. Some cases, the initial threshold requirements weren't met. But they're the vast minority. The vast majority in this settlement agreement, there's never been a settlement agreement where so many people have been successful. In the common experience, for example, over 85% of the applicants were successful. In the IAP, which was more complex because people have to prove what happened to them on the balance of probabilities, even though this happened decades and decades ago, the vast majority of those people were successful in their claims. So, yes, there's some that weren't successful, and yes, there's been problems. Yes, there's been problems with lawyers. Myself, I was a whistleblower, too, about what some lawyer activity that I thought was egregious, and it was found to be egregious. But again, I think the vast majority of legal counsel have been honorable. They've treated their clients with respect, and I think, for the most part, people are very happy. But I agree with Eugene and Mike, there are problems, but I don't think those problems will be resolved by forcing claimants against their will to have their specific private stories revealed to the public.
You're quite right, Professor. We had attempted to get this group together because we wanted to discuss the issues of privacy around testimony. During the course of that conversation, it has become, I guess, clear that certainly the couple of the guests on this program don't think that the process, that the independent assessment process was as kosher as it ought to have been. And so, yes, we have gone off the path here a little bit, but I will take your admonition to heart and try and get us back on the path now that we've established some of those criticisms. Let's get back on the path of what we do now that, and Rye, I'll bring you in at this point, what do we do now that it appears...
Steve, I'm going to interfere here. I want to clarify something.
Okay, please do.
I have a picture here.
Can we see it?
Kids, yes, you can see it. 32 kids in this picture.
Okay.
Only 10 of us are alive. This was taken in 1959. In this picture, I know who abused who on student abuse. In this picture, I know which members of the clergy abused my fellow students, my classmates. I know which members of the staff abused who. Amongst us who are still alive, the 10 of us, have way more secrets than IAP will ever know. And in terms of supposedly protecting our privacy, we've lived with this dysfunction and these feuds in our communities caused by what happened in these institutions for decades. Mm-hmm. And it's important for Canada to know that don't do this under the guise of protecting us, because that's simply not true.
I don't disagree with Eugene at all. There's been people that felt they should have got compensation that didn't. They've gone through the review process and they're not happy with the outcome. Whether those cases should be opened up for further review, the process allowed for several levels of appeal, and there's at some point, I guess some would say, the process has to end. The thing is about filing stories, that people can file those stories too. The research center that Mr. Moran is in charge of has the mandate to accept stories in perpetuity from survivors or their descendants, and to talk about how the residential schools affected them. That is open. That door is never going to be closed. On the point of perpetrators' names, which was raised, and I think this needs clarification too, is that perpetrators' names would never be disclosed, whether the claimants would have won this issue in court or not, because you see, when they'd only be disclosed if they've been found guilty beyond a reasonable doubt in a criminal court. Then their names can be disclosed. But in a civil proceeding, I've had cases myself where my clients were sure of the name. They thought they were sure of the name of the perpetrator. They know they were abused and they were found to be abused, but they got the name wrong. And when they were shown the photograph, said, "Oh no, that's not him. This one is over here." And so young children don't necessarily remember the exact names of who was their perpetrator. So there's those kind of protections too that were built into the system, so that even if records were disclosed against claimants' permission, the names of the perpetrators would not be disclosed in any event, in any records, because that's what the privacy laws require. Unless someone has been proven to be a perpetrator beyond a reasonable doubt, those names would never be disclosed.
Okay, friends, I haven't heard from Ry Moran in a while, and I want to get him back in here because,
sure.
Ry, can you tell us, you are in charge of the National Center for Truth and Reconciliation, which, where exactly in Winnipeg is that?
It's located on the University of Manitoba's campus. That's where we're hosted there. Yeah.
Very good. Tell us, have any records of testimony from this assessment process, have any of those records yet been destroyed?
Okay, so I think there's a lot that we've talked about. There's a lot that we need to talk about. It's important for the public to recognize that, yes, records have been destroyed in multiple ways already. Everybody who has passed away has had their choice removed to have their record transmitted to future generations, which would be in accordance with UNDRIP. So that right has been removed, so those records are effectively gone, whether it's 2 years from now or 15 years from now. What's also important to recognize is that the IAP Secretariat has been ordered to be the only agency to hold a copy of those records. That means that the Government of Canada, which holds a full and complete set of those records, has been ordered to destroy those records now, as with all the churches that also hold partially redacted versions of those records as well. So the record destruction is happening as we speak.
And what's your view of that?
Well, I think it's just reflective of the fact that destruction is not this thing that's way down the road. It's happening right now. We are actively losing history, and we've already lost a lot of history. And when we take a step back and we think about, I think the point that Mike raised is this opportunity that we had to kind of have that sober second thought about the process itself. Survivors absolutely had their guts ripped out in those rooms. I've talked to my friends, and it was a very, very difficult process. Even if the choice was provided then, was that a full informed choice? And what is our responsibility as a society to take a step back and now say, okay, now we are where we are. We're 5 years, 10 years down this process of healing and reconciliation. What is the essential information that we need in order to ensure that this process of healing and reconciliation continues? Central in this is that recognition, and I think Mike flagged this correctly as well. The process itself was so harmful and so difficult for survivors, it was simply impossible for them to tell their story again to anybody. So we did talk to 7,000 people at the TRC. Not all of those were survivors. Many of those were intergenerational survivors that were talking to us about the harms that they carry based on what their parents or even their grandparents went through. That means that there was a necessary kind of gap that has protected us as a society from the harshest stories. And those harsh stories are exceptionally harsh. And the tension that has always existed in this case is, how willing are we to A, protect the confidentiality of survivors through redaction, through sealing the records, whatever it may be, versus facing those hard truths? Because the material contained in those IEP records, second to none, is the record of the worst abuse. And I think we have to recognize that of the 38,000 people that went through the process, 38,000 and change, about 50% of those people experienced the highest level of harms and the most severe forms of abuse. And Canadians need to know just how harsh this was. So we can understand this in the aggregate, but we're never going to understand it in the detail.
Okay, to that end, let me jump in here because, Mike, I want to get your view on this. We have seen with other examples of historic atrocities, it can sometimes be helpful to have an actual physical space that people can visit, that people can study at. I'm thinking right now of, for example, concentration camps in Eastern Europe, where if you were a student of the Holocaust or you wanted to explore more about that, you've got those places there to go to. The residential schools, I mean, they're almost all gone now, right?
They are. There's a few of them. We have the one in Sault Ste. Where Algoma University is situated. But you know, just to pick up, right, if you go back and look at First Nations people being exposed to the residential school, that's a history of 135 plus years, okay? You take a segment of society and you put them through 135 years of social re-engineering.
No,
okay, and the end product.
Understand what the results are.
Yeah, and the end product is these people that lose their identity, lost their language, and lost.
But would it be helpful to the public's understanding of this issue if we had?
Exactly. So what you have to do then is look at the connecting factors. Like I always used to tell the students when I was teaching, we didn't wake up on Tuesday as First Nations people and decide to be dysfunctional. There's a history to that. And one of the greatest contributing factors and what's happening in our societies today is the residential schools. We have 10-year-olds committing suicide, for God's sake. 12 years old committing suicide. So a lot of the dysfunctional behavior in our communities are learned behaviors as a result of what happened in the residential schools. And like Rai said, some of the most horrific things that are happened have to deal with sexuality and physical abuse.
Mike, forgive me, I have to jump in here because tonight the clock is really our enemy. We're plumb out of time, but I want to thank Kathleen Mahoney, Rai Moran, Eugene Arcon, and Mike Kakagi for coming on our program tonight and having what is obviously a controversial and difficult discussion, many more of which we will have to have in the days, months, and years ahead. Thank you so much, everybody, for coming on TVO tonight.
Thank you.
Thank you very much.
Thank you.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.